We're here on case 22-1029, Neighborhood Restaurant Partners Florida LLC versus Kirk Wolf as personal representative of the estate of the former plaintiff. And each side has 20 minutes. You'll see in the little square there is a clock. You can see the numbers very well. Whether you can see the lights or not, I'm not so sure. If I see you're getting into your rebuttal time, Mr. Vernus, I'll let you know. And with that, we can commence.
Good morning. My name is Jeff Vernus. I'm here on behalf of the appellants. I'd like to reserve 5 minutes for rebuttal, if I may.
All right.
Thank you. This appeal asks this court to reverse the trial court's order granting a new trial and other remedies should the court affirm the new trial. I will focus my presentation on the new trial issue, but certainly we are not waiving any of the other issues or arguments we've set forth in our brief, and I'm certainly willing to accept or address any questions associated with that. But with the limited time, I'd rather focus it on the issue with new trials, if possible. If there's time, I'll address the other ones. The factual basis of the lawsuit is this is a lawsuit resulted from a fall by an 85-year-old man who fell going down 2 steps on the premises of the defendants, which was an Applebee's restaurant. The appellee claims that the decedent fell because there was a light bulb out above the steps and there was insufficient markings on the steps. The appellant presented evidence that the restaurant was very well lit during the day, which is when this incident happened, because there's a wall of windows right near the steps where this incident happened. And the decedent did not even know why he fell, but he also had significant medical conditions like chronic dizziness, gait imbalance, leg weakness, poor vision, and walking imbalance. After the evidence and the arguments, the jury returned a verdict of no negligence on behalf of the defendant. The trial court granted a new trial, and it is from that order from which we are appealing. The first issue is the appellees argue that a single comment, single sentence in the counsel for the appellant's closing argument was improper, and that serves the basis of their request for new trial. Prior to trial, the appellant filed a motion in limine seeking to require the appellees to lay a proper foundation prior to bringing in.
Excuse me just a second, counsel. Who's this joining us now?
That's my clerk.
Okay. Sorry. Go ahead.
No problem. Appellant filed a motion in limine requiring the appellees to lay a proper foundation prior to discussing or arguing any prior falls before the jury. The judge initially denied the motion, but before trial, the trial court reconsidered its ruling and stated that that's what I have to do, is allow both of you. And then the burden is still on the plaintiff to show that they were similar. Counsel for the appellant then specifically asked the trial court, you are going to allow both sides to talk about prior falls? And the trial court responded, yes, sir. During 4 days of trial, there was no evidence presented by the appellee on prior falls, and they never attempted to establish any prior similar falls. There was no evidence in the trial or in the record of prior similar falls. During closing argument, counsel for the appellant stated as follows, within a 40 to 45 minute closing argument, this sentence. Also, you haven't heard evidence of one single person who fell going down the steps before this incident, did you? Appellees objected. The trial court sustained the objection and issued the following curative instructions.
Now, hang on a second. Mr. Vernus, you're kind of leaving something out, aren't you? Didn't the closing argument say that if there had been one, don't you know they would have said it?
Yes. Yes. If there had been.
And you don't think that's important to mention? You don't, I mean, I'm not saying that the first sentence may have been okay to say, but it was true. There was no evidence presented of any other falls, period. I'm not saying that you might have gotten away with that, but when you say, don't you know if there had been others, you would have heard about it, which is basically, it may not be the 100% accurate paraphrase, but that's basically what the statement was, which according to the trial judge certainly implied that there had never been any other falls. That's certainly the impression you were trying to leave with the jury. And you had been cautioned, hadn't you, by the judge? And I'm looking at page 31 of the transcript. It's like, okay, Mr. Vernus, so they're prohibited from talking about the alleged 10 or 15 falls that some employees mentioned. But that doesn't mean that you can get up there and say there's never been a fall there before. Do you understand? No one ever slipped on these stairs. And that's exactly what that second sentence, that was what you were implying, wasn't it?
The sentence was referring to the prior sentence, which was there was no evidence. And Judge Edwards, the question is very good because of this point. There was no evidence in the record or presented to this jury that there was a prior fall of anybody going down those steps under any similar circumstances. The judge—
You didn't— similar circumstances was not mentioned in your closing argument. The judge pointed out that had you done that, again, maybe it would have been okay.
But the similar circumstance was falling, going down the steps. The plaintiff in this case, the decedent here, was going down the steps. There was no evidence in the record of any other person or any evidence of anyone falling or tripping going down those steps before the day of the incident. So it was referencing a similar nature to that of the plaintiff, which was going down the steps. That's why, respectfully—
Counsel, your statement, let me read it to you in case you've forgotten what you said. You left it out of your reply brief. Your statement that I think really got the court upset was, if there was one prior fall, you don't think they would be asking about that? If there was one prior fall, you don't think they would be asking about that? That's not similar circumstances. That's not talking about the light bulb. That's not talking about— you said one prior fall.
Yes. And that referenced the sentence immediately before that, which was a prior fall going down the steps. So, yes, I didn't say prior fall going down the steps, two successive sentences, but I said it in the sentence before. That to me was intended to— the entire reference was similar falls. There was no evidence of a similar fall of anybody going down the steps. And that was the sentence before, which is where the context of both sentences put together was. So these sentences, or these two comments, were within a trial of 4 days, 7 witnesses, and the statement was effectively true because there was no evidence of any prior falls going down the steps. However, at that moment, the statements were made, the appellee objected. The court sustained the objection and issued the following curative instruction. Ladies and gentlemen, I'm going to sustain the objection and give a curative instruction and instruct you. There is disregard the comments of the attorney. Remember, regarding you received instructions that comments of the attorneys are not evidence. The appellee did not ask for an additional curative instruction, didn't ask for anything more from the court at that time.
Ask for a mistrial. Excuse me, didn't he ask for a mistrial?
He asked for a mistrial, but
well, isn't that that's asking for relief, correct?
It's asking for relief, but he wasn't asking for a more defined, more stronger, anything relative to a curative instruction. Yes, he asked for a mistrial, but he didn't object or ask for a different curative instruction at all. But yes, they did move for a mistrial.
You made a contemporaneous objection and made a motion for mistrial at that point in time as well, correct? At the bench?
Yes, and I concede that point, yes.
Okay, and you're saying he should have asked for an even better curative instruction, that, you know, the old saying, you can throw a skunk in a jury box, but you can't get the stink away with a curative instruction?
Well, all I'm saying is they never asked for any additional curative instruction if they didn't feel that was adequate, or whether they felt that that was unclear in any way or ambiguous in some way. The judge gave that curative instruction. And Judge, there is no evidence. Well, let me continue. The review is abuse of discretion is the standard of review. To warrant a new trial, the improper argument or arguments must be so highly prejudicial and inflammatory that it denied the plaintiff its right to a new trial or to a fair trial. This court in Lazaroff versus Meek stated that the impact of an improper argument must be so prejudicial as to vitiate the entire trial and warrant a new trial. The trial record, the entire record in this case presented, does not warrant a new trial because no sufficient basis exists to conclude that the statement, individually or cumulatively, rose to the level to demonstrate prejudice to the plaintiff. I want to address each of these issues. The challenged argument must be improper. I suggest to this panel that the single comment, even combined with the second comment, referenced a similar nature of this incident and was combined together, was not an improper comment. And the comment was responding to the plaintiff's claim that there was notice of an unreasonably dangerous condition. Their argument was that the steps, the light was out, they should have known, and that there was a yellow strip on the steps that had worn away and was gone. Their argument was it existed for a significant length of time. So presenting or discussing the lack of evidence presented by the plaintiff about anyone else going down the stairs is similar to what was happening in community asphalt. A party is allowed to comment on the lack of evidence supporting an opposing party's position. And that's what the comment was. If you read both sentences together and in context, they talk about prior similar falls, similar to that of the plaintiff. Even if the court considers the comment improper or objectionable, it was an individual comment, not cumulative, and it did not rise to the level of the improper comments that were found in Lazaroff or in community asphalt, which would not warrant a new trial. If the court believes that the comment or comments were not improper, then the inquiry ends. If, however, the court believes that it may have been improper, then the next prong is whether the comment was so highly prejudicial and inflammatory that it denied the plaintiff its right to a new trial.
Are you relying on the Murphy case for these four factors? Where do you get them from?
I am relying on the Murphy case, but that is not the standard for this appeal. I recognize that. Okay, and I do, because the Murphy case dealt with unobjected to. This was objected to and properly preserved. I could see that point. But the court, what I'm relying on is the Lazaroff case together with the Engel case. Murphy is part of it. But in order for the court to grant a new trial, it must be so highly, must find that it was so highly prejudicial and inflammatory that it denied the plaintiff its right to a fair trial. So here, the comment or comments together were not so highly prejudicial within a 45-minute closing argument that was objected to, stricken, contained within a 4-day jury trial with 7 witnesses. Harmful in this context means the improper closing comment or argument must be such a nature that it reaches into the validity of the trial itself to the extent that the verdict reached could not have been obtained but for such comments. That's found in Carnival versus Jimenez at page 521. It must rise to the level of such an incurable prejudice that justice requires a new trial. Here, there was ample evidence in the record for the jury to reach the verdict that it did. There was significant evidence to support the finding that the plaintiff did not prove that the cause of the fall was due to the negligence of the defendant. The decedent had significant medical conditions, which I've outlined before: gait imbalance, leg weakness, chronic dizziness, walking imbalance, poor vision that could have caused him to fall. The decedent did not even know why he fell. He was
Counsel, the judge agreed that there was plenty of evidence in the record that could have supported a verdict for either side, correct? Isn't that a finding he made?
Yes.
Okay, so I understand what you're saying. There was plenty of evidence there, but when you're cautioned before trial starts not to stand up there and say there were no prior falls, and that second sentence, that's essentially what you said, that if there was one prior fall, you don't think they would be asking that? one prior fault. You did exactly what the judge told you not to. How are we to sit here and say the judge is wrong for finding that the prejudice was of such a magnitude that it wasn't cured by the instruction here?
Because if you take the sentence and the sentences in context, there were two sentences together. There was a period in between, but there were two sentences together. So when you talk about prior similar falls, meaning somebody going down the steps, and I said this before, if you take those in context, it references the exact same thing. And the one comment, the judge sustained the objection and issued this curative instruction. I recognize, Judge Edwards, what you said about distinct to the jury, but there is no basis to recognize or believe that this jury completely disregarded the trial court's instructions. Because in a case where there is significant evidence or substantial evidence or enough evidence to support the jury's verdict, it's impossible to say, oh, that one sentence caused the jury to do something, because there was significant and sufficient evidence for the jury to rule what they did. And that's
the trial judge found that one statement about implying that there had never been a prior fall. He found that was not true, correct?
He found that one
sentence in his order granting the new trial, which I'm sure you've read, he said that was not true.
In that order, respectfully, which the court adopted the plaintiff's proposed order verbatim, did make that finding, yes.
Okay, you agree that it's not appropriate for counsel to stand up in closing argument and say something that's not true, don't you?
I don't respectfully believe that was an untrue statement. I recognize the trial court entered an order that said that.
I understand. My question to you is, you don't think it's okay to get up and lie in closing argument, do you?
Oh, no. I don't believe it's appropriate for a trial lawyer to stand up and lie in front of a jury. No. You've
got about 3 minutes and 15 seconds left total. So do what you want to save that for rebuttal, or talk about whatever you want to. It's your time.
Okay. I'll save the 3 minutes and so left for rebuttal. Thank you.
Okay. Thank you. Okay. Mr. Lee.
Yes, Your Honor. May it please the court, good afternoon. Nope, still good morning. My name is Brian Lee. I'm representing the appellee in this case, Mr. Wolf. And I want to start off by talking about the standard of review in this case, because it's been muddled. But I think it is clear, and I think the court's already addressed or touched on it, that we are not under the Murphy standard for this case, because this was certainly objected to timely. There was a timely motion for mistrial, which the court reserved jurisdiction on. And then plaintiff's counsel actually then went further and asked for a curative instruction. They didn't actually need to under the standard, but they did. Touching on the curative, because that's become part of the argument that's been done in this case, is that somehow the plaintiff's counsel should have done a different curative. My argument to that, Judge, is that, and I'm sure the people on this panel would know, that when you do curative instructions, the one thing you don't want to do with a curative is re-emphasize exactly what the error just was. And so having a curative instruction that would have said, jury, you should disregard that comment that said da 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 da. You don't want to do that. Certainly as a judge, you want to make it as vanilla as possible, because you don't want to highlight again the comment that was just done. The court did what I would consider a standard instruction, but he also realized after the verdict and after looking at it again with the transcript, that this particular set of comments went to what I think appellant has already conceded was the issue of the case, which was liability. And I would respectfully disagree. And I think, Judge Edwards, you've already noted this in the comment. When we look at the transcript of this comment, There is not the word substantially similar or even similar in it. And it says specifically if there was one prior fall, period. Right? So and we know this because the judge in very real time, after hearing these comments, after seeing the objection, went directly to that and talked about, and even said, look, if you had said substantially similar, we may be talking about it still. I still think it might be improper, but we may be talking about it. But you didn't do that. And obviously this is to Mr. Vernis. You said prior fall. And so the judge reserved mistrial, obviously sustained the objection. When we now look at that comment, there's very rarely that I say that attorneys, lie in front of a jury. I don't do that. That's not my role in here. But when you come in front of a jury and say, if there was one prior fall, don't you think they would be asking that? We know that there were prior falls. We know that there was evidence of prior falls. The trial court didn't allow that evidence to come in and said basically, look, I don't think that's substantially similar. And so there was an evidentiary issue of hitting all four of the prongs to get that substantially similar evidence in. But there was no ruling by the trial court that I'm finding that there were no prior falls. None of that, because we knew that there were. And for Mr. Vernis to then come up in front of a jury and essentially inject not only himself, but to dare Wolf and his counsel to prove him wrong, that's what was improper. The trial court was very succinct in his order when he talked about the one prior fall comment and said that because that was so pervasive, it cut to the heart of the essential issue in this case, and it was improper. The trial court's order, and obviously this court has read it, is very detailed. And the analysis that the trial court went through. And at the end of the order, it says, the trial court says, when considering the defendant's comment on this essential issue, this was highly prejudicial and inflammatory, and plaintiff was not granted a fair trial. When liability is at issue, curative instructions are usually insufficient to cure the error. That's from the 5th District Court of Appeal. And it said here, the court finds that the curative instruction was insufficient to cure the defendant's error. And so what we have to prove, it's really not us, the defendant has to prove an abuse of discretion. They have to prove that the trial court's order was not something that a reasonable judge in that position would have done. There is nothing that I can see in the briefing that would prove that, because what they've chosen to do is try to bring it under the Murphy standard. That is not the standard in front of the court. And so when the court looks at the actual standard, I think there's only one conclusion. The trial court was well within its discretion, the trial court was the judge that was there during the trial, saw the evidence come in, made all the pretrial rulings, cautioned counsel not to do it. The evidence goes through, plaintiff does his closing argument, and then in Mr. Vernis's closing argument, this is injected. There's no way for plaintiff to come back from that. And there's no way for a jury to unhear that. That's essentially what the trial court held. And so we believe that the trial court's order granting a new trial should be upheld just for the very fact that it was correct. Not much less, it wasn't an abuse of discretion to do so. If the court wants to go through the other arguments, I would rely upon the arguments in my brief. For those, the evidentiary issues, I believe in every single one, the court did not abuse its discretion in what the court did during the trial. But certainly I'm open to any questions if the court has any for me. If not,
I don't see
then,
any hands raised by my colleagues.
no hands raised.
All
Okay.
right, thank you.
I didn't, normally with jurors we have paddles, but I wouldn't do that, of course.
No paddles, no anything. So,
no
all right,
paddles.
well, we'll go back to Mr. Vernison. Thank you.
Yeah, sure. Thank you.
Thank you, Your Honor, or judges. The entire record in this case doesn't support the order granting new trial. If you look at the single isolated one comment, it's insufficient to prove such severe prejudice as to vitiate the entire trial. If you look at the entire record in this case, which is what the court should do, in the entire record of this case, it doesn't support the order granting a new trial. The one sentence in a 4-day jury trial, which was objected to, sustained, and the jury was told to disregard, was sufficient for what the court did in order to not disturb the jury's verdict in this case. There was ample evidence for the jury to reach the verdict that they did. The court even said there was sufficient evidence for the jury to reach the conclusion that they did. That in and of itself is sufficient for this court to
Counsel,
the order.
the trial judge also said there was ample evidence that would have supported a verdict for the plaintiff.
Yes.
And if that one sentence was so innocent and so innocuous, it makes me wonder why you left it out of your reply brief when you said that the comment in question was, also, you haven't heard evidence of one single person who fell going down the stairs before the incident, did you? That's all you put in there. And I really, again, I want to be very clear. If this case goes back to retrial, I'm not stamping that as okay or giving it my thumbs up that that's an acceptable statement. So don't take that the wrong way. But you left out the other sentence, which I think really was what everybody, including the judge, was upset about, because he said there was evidence in the record, not evidence at trial, but evidence in the record that there have been 10 or 15 other falls at that location, and told you not to get up there and say there had never been another fall. And that's essentially what that statement did. And I understand you're saying you got to read it in context, but are you saying that no other judge in the state of Florida would have granted a new trial under these circumstances? A reasonable judge?
I mean, if you
Well,
want
that's the standard. That's the standard, isn't it?
Right. No, I don't think that a judge who sat through that entire trial, saw the evidence in that case, listened to all of the evidence, and made the rulings that they did, would have reversed the jury's verdict in this case. So respectfully, I think that the evidence in the entire trial clearly supported the verdict, and clearly that now you're looking at one sentence. So the sentence before is okay, but the sentence after the court finds potentially objectionable. I say if you look at them in context, then they're not, and it's not a misstatement, and it's not so unfairly prejudicial that it vitiates the plaintiff's right to a fair trial.
All right, thank you. We're out of time, so we will be in recess. Thank you very much.
Thank you.